I know you were going to determine whether there was any 1998 material.
There is. I showed you those sites, which were from 1998. We have Mr. Cook right now going on the unallocated space off the Jensen home computer. He's, last I heard, he recovered some photos of fellatio-type photos. I think he found 2 thumbnails. He said we're unlikely to find full-size pictures, but he would expect to find some thumbnails.
What's a thumbnail?
A thumbnail's a small picture. It's a picture about this big of what.
Can any picture be magnified?
I'm sorry, but I'm not following you.
You say it's a thumbnail, but I thought any picture on a computer could be.
You may be right. I have no idea. I'm not a computer expert, and all I know is that he's found a couple of thumbnails, and but he just started looking, and he's looking in unallocated space.
Well, see, that would strike me when I'm not going to depart from my initial characterization of the material as cumulative, but you know, as something, as the, how shall I put it? As the gun gets smokier, it becomes less cumulative. And I'm not suggesting this is a smoking gun, but the point is it's more directly probative. So if there is 1998 material, Mr. Albee, I would be interested in your response.
Judge, I guess maybe I should have looked up the percentage of people in this country looking at pornography today, because it's an enormous number. It's a high percent. There's nothing particularly unique about somebody looking at.
There is something unique here. There's something unique. Now, Joe, the record will reflect that during the break, Mr. Jamboys presented me with what will be marked as the next exhibit number. What is that going to be?
269.
269. You had a chance to look through it too, and I didn't look at it, but maybe for 3 or 4 minutes. But what struck me about these photographs is that the focal point of every one of them is the penis. Whether it's the penis by itself, the penis in an act of fellatio, or there's some outliers, I guess, I'll refer to them as. It's none of them that I saw, and again, I did not look at every one of them, but not one of them that I saw depicted an act of penile, vaginal, or even anal intercourse. I mean, it's all, the penis is the center of every picture.
Those aren't all the pictures, number one. But if I could, Judge, because every time I get interrupted, and I haven't been able to make the argument yet. I mean, it's so. Those photos. Let's just talk about those photographs. Those are on a computer that's seized in 2002. As far as I know, there's no evidence that that computer ever was in use before around 2000. I'm not, maybe it's 1999, something like that, but sometime after Julie Jensen's death. Therefore, that computer could not have been used to produce any photographs used for harassment. The starting point here is that, and there's no claim that those photographs are admissible independently as other acts to prove the homicide. By that I mean, it's not that those provide a motive for the homicide or that those identify Mr. Jensen as being more likely. They're being...
Well, it identifies him as, I'm going to interrupt you. I'm going to interrupt you so that we don't argue something that isn't so.
I think I'm getting to where the court's going. But.
Well, you say they don't identify him as committing the murder. Well, they can be used to identify him as having engaged in the tormenting harassment.
And that's exactly what my next sentence was. But that, I mean, that's the point. I'm trying to take a step back and look at this whole context, Judge. And that's what they're being admitted for, is a secondary to try to prove the harassment, which he's not on trial for. And it's being used as identity evidence as to the harassment.
Right.
Okay. So, and when we have identity, we have to have very strong similarities in time, place, and circumstance. Typically, I mean, oftentimes the cases talk about an MO. all right? And we don't have very close time period because we're 2002 in the harassment. The photographs that we were talking about are 95 and 96. So it's not.
I thought you said 98.
There's the one single report that.
No, I'm sorry. I'm talking about all right, I misunderstood which photograph. You're talking about the ones that were the tormenting photographs?
Yes.
Go ahead.
Those are like 95, 96. I think the only report that is in existence is 1995 relating to the harassment. And that relates to that photograph which was found in July of 1995. So we don't have very, very close in place time. We don't have the same circumstance because those are found on the computer. They're not placed on a truck. We don't have any contemporaneous police reports or claim by the officers at the time that these are computer generated, so we don't have that kind of similarity either. I don't believe what the court has in front of it is the entire amount of photographs because the state's offer of proof from September 13th, 2007 says that there are 5,350 sexually explicit images, and it says 351 images are of oral intercourse. So that's less than that's like 4%. And which I don't think makes that too much of an MO. The claim to the photographs that were left as part of the harassment was that they resembled Mrs. Jensen sufficiently that she asserted to two officers that they were her. So we don't have this close identity between what the images on the computer are to harassment. They're not for that purpose. They're just on the computer. They're pornography, and there would be hundreds of thousands of people with pornographic images on their computer as of 2002, and it doesn't make any of them. That doesn't make any of them fit an MO for planting the photographs earlier.
Well,
in terms of probative value. Because we are one step removed, we're not using this evidence to prove the homicide or any mental state related to the homicide, but to prove a mental state related to the homicide. That reduces their probative value even if there was a closer connection. In terms of unfair prejudice, this does unduly influence the jury to decide this case on something other than the proof of homicide. And at the end of the day, I think this is nothing more than a smear campaign. And that's why we're continually showered with these graphic images and the names of websites. Well, that's what pornography is, but there's nothing that specifically identifies Mr. Jensen as being unique in that regard of having the pornography or connects it so closely to their harassing activity. Well, and then we have confusion of issues. We have undue delay. I mean, this is all undue delay, and I think cumulative. And
let me ask you. I don't know if is this all the photographs? You say there's 5,300. And I guess I want to understand that I've got a representative sample up here. Are there photographs stored that depict other things such as naked women?
All I can tell you is this, Judge. Here's what I asked Mr. Cook to do
He's in the room now.
Marty, come up here, please. The judge just asked if that packet of photos that I gave to him are all the photos that were taken off the work computer.
Of the 2002.
The work computer.
They're not all the photos.
Well,
Okay,
they
so
all appear to, as I said, the focus of every one of them that I saw is the penis. And I'm wondering if there are others that depict naked females or acts of sexual intercourse that would not even show the penis, or...
Well, I think it was said that there were over 5,000 images. I think it was said that there were over 5,000 images on that computer.
Right.
I didn't look at all of them. Or if I did, it was quite a while ago. So I can't comment really on what the contents are.
Well, see, the significance of it is that the statement is on one of the pictures. Mine is bigger than his. His is bigger than
mine.
His is big as mine, and this is a departure from just somebody having a lot of material stored on his computer. This is all about the penis. I wouldn't even say that I would expect a homosexual individual to have this kind of a storage of just the penis. This is a fixation about the penis. And the other thing is, there are many of them relating to fellatio, and there was suggestion in the record that Mrs. Jensen had complained to the police that her relationship with the defendant was rocky because the defendant was, or because Mrs., did I hear wrong? That Mrs. Jensen was concerned that her husband was upset because she wouldn't engage in this kind of sexual activity with the defendant? Yes, and so, you know, this all does weave together.
Judge, it is, that hardly makes it an MO, and the court is picking and choosing very,
I'm trying not to. I want to. That's why I asked if there are photo images other than those which have as their central
and there
focus
are.
the penis.
There are. Those aren't all the pictures.
I don't know.
Well, I do. Those aren't. He just said they weren't all the pictures.
I know they're not all the pictures, but I don't know if that's what all of them depict.
But the thing is the harassing activity. There were Officer Cosman talked about over 50 pictures, and he said they ran the gamut of sex acts. They weren't all focused on the penis. They weren't all oral sex. So even if those are, it doesn't mean they're identified because the original ones weren't. And we have one photo where there's a claim about he's bigger or whatever like that. It would be nice if we had that in evidence. That in itself lends to unfair prejudice and reduces the probative value because there are no contemporaneous reports. This is 15-year-old stuff that Mr. Jensen is supposed to defend against. There's not one. Not only is there no evidence of this writing anywhere, but we don't have a single contemporaneous report that says that writing existed on the photograph, as far as I'm aware. And the crime lab, when they did look at the writing, said it was probably not Mr. Jensen's. So
that was a postcard, Your Honor. That was not the photographs, and that's the second or third time counsel's made that misstatement. The only reference from the crime lab concerning the handwriting during that period pertained to a postcard, which is in stark contrast to the real pattern of harassment that was taking place here.
Well, I'm not going to do anything about it until I get an idea what's in the 1998 materials.
Well,
I can tell
the
you.
1998 materials are simply looking at websites. And again, I presume websites have all sorts of different kinds of acts.
If one is at a website, one can download a picture, yes?
But there's no claim that any pictures, and Detective Ratzburg just described them all as 4x6 photographs or photocopies of 4x6. That's not consistent with being printed off a computer in the mid-1990s. Because this is 1995 or 1996. And there's no connection to any I mean, there wasn't even any testimony or contemporaneous report that these are computer generated, which is just one more area where there's a lack of similarity that you would need to put in stuff that happened in 2002 to try to prove some act that supposedly supplies some motive for something later on.
Well, the fact that they're from 2002 is still the major impediment to their receipt.
May I will just say this, Your Honor, and first of all, I don't have Officer Cosman's testimony from this hearing. I have a transcript of his testimony from the forfeiture hearing. And he was asked, how many photographs in total do you think, and this is page 102, by the way, how many photographs in total did you receive during this period? And the 50 or 60, he said. And then the question on line 22, and how many of those are photocopies? Answer, most all of them. Question, none of them appear to be computer generated. True. Answer, it was undetermined by me. They just looked like a Xerox copy of a photograph or something taken out of an adult magazine. Were they black and white? Yes. Now, and then if you'll recall, Your Honor, there was testimony that Julie Jensen had to produce a garbage bag full of these photos. There were, and if you look at the Julie Jensen's log, these photos are being left. Oftentimes, we have 2 or 3 a week around the residence. There was just a huge quantity of these photos, and then and it's clear that Julie Jensen was talking with Mark Jensen about this, because at one point in one of her little notes, her talking points that she prepared for law enforcement, it's clear to me that these were talking points where she could argue against the police officer's conclusions that Mark Jensen was the source of this harassing activity. And she indicates there, Mark's computer doesn't have photo generating capacity. Well, clearly she got that from Mark Jensen. She doesn't know what Mark Jensen's computer at work does or doesn't do. But then you put that in with what we know that most any work computer can do in 1998, and we'll have expert testimony as to what what a computer could do in 1998. And
They weren't left in 98.
I'm not finished talking, counsel, and I'll let you finish. Now I'm.
Yeah, finish your remarks, Mr.
And so Mr. Cook can testify that, yes, computers in the mid-1990s and in 1998, if you've got a picture on the screen, you can press print, and if you've got a laser printer or an inkjet printer and it's black and white, it'll print up something that looks like a photograph, but it looks like a photocopy of a photograph. That's how it would look. Exactly the way they were getting them. Now, Judge, in terms of this coming from 2002, you go back and you look at the home computer, and I think it was purchased sometime in early July 1998. All of those sites that I was describing to you, and I didn't describe all of them, there's just site after site after site, lots of smut and so on and so forth. They were accessed on July 16th, 1998. So it didn't take him very long to get to, I think the computer was turned on July 12th. And then the next time it was used, it was July 16th. And so it didn't take him very long, Your Honor, right after he gets that computer, to get right to the issue that is of interest to him. Now, he destroyed the hard drive on his work computer in 1999, after he'd had that conversation with Dave Neary.
Been through this. Look, my position remains I would like to see the materials that were available for print in 1998, and now I'll make a decision about this. But Mr. Albee, I'll tell you, I'm not so swayed by your idea that this is all going to paint the defendant in an unfavorable light. As you aptly point out, there's so many people with this kind of material on their computers. What's the harm to him? That's you characterize it as almost normal behavior. So how is it going to make him look so bad?
I don't characterize it as normal. There are people.
Common behavior.
Yeah, and there are people who spend their lives protesting against this stuff. It really offends some people to a very, very serious degree.
And didn't you voir dire the jury about that?
Very minimal, because I didn't know what was coming in, and so I didn't want to make a big deal about it. I think I asked one.
The district attorney had asked to have it come in.
And I had heard the judge say it wasn't coming in, so I spent very little time on it.
This is exactly why I said before we made the pretrial rulings, and I said again during this trial, this is why I don't like to make pretrial rulings if I can avoid them, because the course of the river changes, and people who think you can try a case off a script, they ought to read this transcript.
Well,
I never had one like this in my life.
I didn't have that response until the court tried to claim that I'd sufficiently voir dired them and would know what their feelings are about it. Even if I did voir dire them at length, I wouldn't be that confident that there wouldn't be some people who would be greatly offended by this material. I think this is a smear campaign. He's trying to paint it. No, he tries to paint it weirder. He tries to paint it more strange and strange. The court itself, I know, initially used the word deviant and then changed. A lot of people think that.
Mr. Albee, listen. Unless I'm missing something, unless I'm the one now who's in another courtroom, before the jury is done with, before we're done with this case, guilty, not guilty, the jury's going to believe your client was carrying on an affair. Now, why they would get so up in arms because he's got some pornography on his computer, get serious.
Oh, I think the nature of the conversations and the sexual explicit nature of those conversations that were illicit, that were sexually explicit nature of those conversations with Kelly Labonte and asking her to describe her former lovers. Yeah, I do think that's on a different. I do think that's on a different plane, and I think it's denied Mr. Jensen a fair trial. I have no doubt that it's denied Mr. Jensen a fair trial. It's violated his right to state and federal due process.
You've said all this before. I don't want to hear it again. I'm telling you, we're talking now not about the past, we're talking about the pictures. And I'm telling you that with all the lurid material that has already been spread on this record, and you can argue that it shouldn't have been, but it's there. With all the material that's already on this record, I find it hard to believe that some stored or printed pornographic pictures are going to push the jury over the edge. I don't see it. But I'm drawing the line, Mr. Jamboys. This 2002 stuff, I don't want to get into that at this point in the trial anyway, and you'll need to show me what came in and what was available in '98. Are we ready to go?
Yes, Your Honor.
Ask the jurors to come in, please. Here's that exhibit.
Please be seated.
Good afternoon. Let's continue with your examination, Mr. Jembers.
Thank you, Your Honor. Detective Ratzburg, do you recall about what time of day it was and what day it was that you released the residents, the Jensen residents, back to Mark Jensen?
December 4th.
Do you know about what time of day it was?
It was in the afternoon.
Do you remember anybody else being there besides you and Mr. Jensen?
Well, objection, that's contrary to the testimony.
Restate your question.
Do you remember if anybody else was there besides you and Mr. Jensen?
He hasn't testified that Mr. Jensen was there, and that's contrary to what he said on cross.
Oh, I misunderstood then.
Well, then I misunderstood. I'll restate the question.
Go ahead.
Was Mr. Jensen there when you turned the house over to him?
I don't believe so, no.
Well, where was he?
I'm assuming either at work or at his parents' home.
Well, how did you get the house key over to him?
And I can't recall exactly, but I believe I may have left it with the officer at the scene.
So when you were releasing the house back to Mr. Jensen, you did so via telephone?
Yes.
Now, at some point during the course of your investigation, you had occasion to speak with Laura Schur, Eric Schur's mother?
Yes.
When did you first speak with Laura Schur?
I don't recall the exact date.
Do you know if it was more than a month or less than a month after Julie Jensen had died?
It was less than a month.
Do you know where that is on his report? Do you? Would it refresh your recollection to review the report that you prepared in this matter?
Yes.
I'll direct his attention to page 17, bottom, and then up to the top, page 18. I'll direct your attention to the bottom, page 17. I know this has been marked as an exhibit, but I forgot the exhibit number. Directing your attention to the bottom, page 17 of your report. Please read that to yourself, and then go to the top page, the top of the page 18.
Yes.
Now that you've read that, does that refresh your recollection as to the date and time that you, or at least the date that you spoke to Scott and Laura Schur?
Yes, it would be December 9th.
Where's that office leading? I don't have further questions, Your Honor. Thank you.
Mr. Albee?
Detective Ratzburg, you were asked questions about your interview with Stacy Bauer. You recall that?
Yes.
And you were asked to review a handwritten statement, correct?
Yes.
That handwritten statement was written out by you, correct?
Yes,
Reflecting some of the information that you had received from her, true?
true.
It by no means was a verbatim account of your entire conversation with her, true?
True.
You also wrote a narrative report in this case regarding your conversation with Stacy Bauer?
Yes.
Can you find that? There you go, thank you.
You wrote a narrative report that you typed out yourself that also summarized the conversation with Stacy Bauer, true?
Yes.
And I take it that you typed that up to be accurate, correct?
Correct.
I show you Defendant's Exhibit 270. Is that a narrative report prepared by you that recounts several of your interviews, including your interview with Stacy Bauer?
Yes.
And Detective Ratzburg, could you just read the entire paragraph in which you summarize your conversation with Stacy Bauer?
On 8/10/07, I spoke with Stacy Bauer. She was Ed Klug's secretary in 1998. Stacy does not recall Ed Klug speaking with her about a conversation Ed and Mark Jensen had in St. Louis. She was aware that Mark and Kelly were having an affair, and later Kelly moved in with Mark Jensen.
Thank you. So according to your narrative report, she didn't recall ever hearing about any conversation between Ed Klug and Mark Jensen in St. Louis, right?
Yes.
Detective, as of the time you arrived at the Jensen home on December 3rd, 1998, you were aware of Julie Jensen's claims about things being on the computer, right?
Well, I don't know about things. That time I had information that Mark Jensen frequently used the computer/internet.
That's information that had been reported by Mr. Cosman, right?
Yes.
You indicated on direct that that's because of that information that you had, you immediately knew you wanted to seize the computer, right?
I gave it some consideration and did seize it, yes.
I think you said on direct that that was a reason why you got Mr. Jamboys involved, so that if necessary, you could get a search warrant to take the computer.
Correct.
You didn't have to do that because Mark Jensen consented to taking the computer, right?
Yes.
But it is fair to say that as of that date, you knew the computer might have some importance in this investigation, right?
Yes.
You testified on redirect as to a conversation you assert happened on December 3rd about computer use, right? You recall that? About whether Julie Jensen used the computer?
I'm not sure it was December 3rd, but sometime in December we had a computer usage discussion.
You didn't write down in any report anywhere anything about that alleged conversation, did you?
I don't believe so.
Would you like to review your report?
In one spot I would, yes.
Regarding a conversation in December of 1998? Yeah, I think that's part of it. Yesterday.
Yes.
Let me, as I grab 258, let me just Exhibit 271. Thank you. Let me show you Exhibit 258. And this is your 32-page narrative report in this case.
Yes.
And what information do you have regarding the computer? Any conversation about the computer in December of '98?
This here is everybody's report, so it's going to be
I
just...
think, Detective Ratzburg, feel free to look whatever you think you should look at, but I think, generally speaking, your activities in December are documented from pages 15 to 18.
Yes. Hey, would you repeat your question? So
Yes, I'm just wondering whether you given the importance of the computer in your investigation that you're aware of on December 3rd, did you document anywhere in your report any conversation with Mark Jensen in which he said Julie Jensen did not use the computer except for Quicken?
No, that's not in the report.
You did not include that anywhere in your statement, right?
In my narrative?
Yes.
No.
Any other statement that you can think of in which you included any information?
I recall it in a transcript.
In testimony?
No. There was some discussion on possibly in April, but I'm not sure.
Oh, you mean in the recorded statement?
Yes.
Yes, well, we went through the testimony in April.
Yes.
But Mr. Jamboys asked you a question as to whether Mr. Jensen had ever said anything like that in December, and you indicated that he had.
Yes.
Right? But you have no documentation of that, right?
Yes.
You agree that you
Yes.
don't?
I agree.
And you also had an interview with Mr. Jensen on December 6, 1998, correct?
Yes.
And what you did is, after talking with him, you wrote out in your own handwriting a statement about your conversation that you'd have, correct?
Yes.
Four-page written statement?
It could be that long.
And what you did in this statement is you put in whatever you thought was important that you had talked with Mark Jensen about on December 6, 1998, correct?
True.
And in this written statement of December 6, 1998, well, first of all, is Defendant's Exhibit 271, is that the four-page statement that you wrote out following your interview with Mark Jensen on December 6, 1998?
Yes.
And what you did is you summarized what you thought was important about your interview with him that day, correct?
True.
You did not include any information about computer use in that statement, did you?
I doubt it, but
Sure,
let me
take your
just
time.
double check. That would be true.
You would agree that there is no written statement documenting any such conversation, correct?
True, yes.
Mark Jensen signed this statement, Defendant's Exhibit 271, the December 6, 1998 statement?
Yes.
Detective Ratzburg, my recollection from Friday was that you didn't specifically recall when or how the home was released back to Mr. Jensen on December 4th.
Yes,
That would be fair to say.
yes, I would be.
Would you agree that Officer Cosman saw more of the photographs allegedly involved in this harassment than you did?
Yes,
You saw less than, I think you said less than 10 photos?
correct.
And some of those were actual photographs, right?
I'm not sure if they were actual photographs.
Well, the one you have in front of you is an actual photograph, right?
They appeared to be. Let me,
Okay. Did you try to track those down and see if they were actual photographs?
no, I did not.
The other ones appeared to be photocopies in about the same size of the photograph as the photographs, right?
Yes,
They weren't, well, I think you said they weren't 8 by 10s, right?
they were a smaller size.
And they weren't like, what's the size of paper, 8.5 by 11? They weren't like this size
they
sheet,
weren't.
right? Yeah.
No.
When Mr. Jamboys was reading the transcript of your interview, you recall that on
Yes.
redirect? He wasn't necessarily reading with the same inflections that you were using and Mr. Jensen was using in the interview. That'd be fair to say?
Yes, I think that'd probably be fair to say.
Did you ever see My Cousin Vinny?
Yes, I have. No,
Do you recall that part where Ralph Macchio is interviewed and they accuse him of shooting the clerk and he says, "I shot the clerk"? And then the cop testifies at the trial and he says, "And then he said to me, I shot the clerk."
yeah,
You understand how inflections can change the meaning of what's in a transcript?
yes.
Okay, that's all I have.
Mr. Jamboys, do you have any reflections?
That was one of my favorite movies, but I'm not wearing a tux tonight. I have no other questions, Your Honor.
You may step down, Lieutenant.
Your Honor, our next witness is going to require some setup time, so I'd request that we take a short recess so that he can set up his stuff.
All right, let's take a recess. Please don't talk about the case during the break.
Please all an opportunity to highlight those portions of post-140 transcript that I thought were relevant to Aaron Dillard. I thought I'd take up the court's suggestion that if I'm going to do that, I'll recall Detective Ratzburg just on that issue and go through it then, and we'll have time rather than taking up the jury's time before.
Very fine. Thank you. Okay. Now, let me just tell you, and he can start setting up while we do this. I did get an email from the attorney for the message board agency. And he says, "Dear Judge Schrader, I understand that you have now identified the juror at issue. In light of that, do we still need to proceed with searching for and collecting material that responds to your prior inquiry in which I had asked for the actual posts?" Do you gentlemen have a sentiment on this subject?
I don't see it.
Yeah, I think that would be better. I'll respond and tell him yes, and if he needs a separate court order, I'll give him one.
Thank you, Judge.
All right, thank
How
you.
long recess do we have?
As short as possible.
Okay.
We don't talk long, we talk short. What's up now?
Well, Your Honor, I just showed counsel this document that it's 149 pages of the Jensen home computer all internet history. And this was provided to me by Mr. Cook. This is an item that was first produced by Mr. Cook, I believe, in 1999, and has been provided to defense counsel, if not in hard copy format, at the very least in disc form. But the court had indicated in response, in the process of denying my motion to admit testimony regarding the work computer, you indicated, well, show me something that's on the home computer. So this starts on page 118. It works backward to forward. So page 149 is when the computer's first turned on, July 10th or something like that, I think. Well, actually, no, it isn't. I guess we just go right to page 149, and it's got cookies. And so the cookie at the top of the page is cookiebuddy@abcnews.com. Then underneath that, cgi.sexswap.com. Then shop.orvis, and so forth. Then down below that, www.sexbytes.com. Then underneath that, www.studcityusa.com.cgi.bin. Underneath that, www.adamsxxx. Underneath that, sexhound.com. Underneath that, gaysexswap.com. That's on page 149 of page 149. Then, on page 148, there is a series of intranet Stiefel Nicholas things. Then underneath that, Health Think, and then Asperline Log Homes, then Marriott Hotels, Microsoft, then www.sexswap.com. Underneath that, Wilson's Leather. More stuff of not much interest on page 148.
Maybe not any interest to you, but the
Yes.
Marriott Hotel on the would be non.
Yeah, well, it's Marriott Hotels, www.marriott.com.
I think it's clear where you're headed.
Yes. And you go to the next page, page 147, and among the things there are adultcheck.com. Then there's the ad server, The Street. Clearly that's stuff that he would be interested in as part of his job. More Stiefel Nicholas sites. Then page 146, more adultcheck.com.
Go ahead. What's the point of this?
Well, then once you get beyond that, you get up to page 118. Actually, it wasn't 118. When you get to the sites that are listed by date and time, it appears as though the computer was first turned on sometime around July 10th, and there's stuff here on July 6th, so apparently the computer was turned on July 6th.
Mr. Jemley,
And
get to the point.
well, Your Honor, I'm paging through it. It takes a while to get
It
there.
was 149 pages, and I'm not going to sit here while you page through all of them.
I'm not going to page through all of them, Judge.
You gave it to me to look at. It was very evident that it gets into a situation where there's one after another.
Here it is,
All right.
page 105. Voyeurs.haven.com, denverdigital.com /Jamie, allsexybabes.com, members for free, whatever that is. Then Nextdoor Gallery, XXX Nextdoor Gallery.
I get the drift.
Yes.
So what do you say?
Well, Judge, I want to introduce evidence concerning this, since you've indicated, well, the other stuff, which I think is more specific, the stuff off the work computer.
Here's how I'll put it, and I'm going to ask you to respond, Mr. Albee, is that someone in the, let me start over. It seems to me to be an argument made by the defense that the decedent was the one who was at least a partial user of the computer and perhaps the principal user of the computer. It would be possible for the jury to conclude that someone was a very avid surfer of the internet, which, by the way, is an accusation made by the decedent in her letter. And one would think, well, who's looking at these sites? And I suppose the 2002 materials that were found on his computer at work would suggest that perhaps it was the accused who was making these visits to these pornographic sites. At what hour were these sites being hit?
Well, there's a wide variety. Let's see. On July 11th, amateuralley.sexycity.net was accessed on July 11th at 6:44:04 p.m. At 6:44:47 p.m., cumavenue.xxcity.net. At 6:44. cumavenue.xxx.
I'm more interested in the late night hours, if there are any.
There's plenty, Judge.
Well, here, the point is that the 2002 materials would suggest that the defendant was going to pornographic sites and perhaps homosexually oriented sites even, perhaps. If that evidence might be of value to the jury in deciding who it was who was going to similar type sites on the home computer back in 1998.
Well, Judge, all this internet history that Mr. Jamboys is referring to in terms of this adult stuff is all dated in July. And we don't have things like October 16th, I think, is one of the dates in which botulism is looked up, for example. And we don't have botulism sandwiched by...
Except the state has tried to prove, while this case has been before the court, that Mrs. Jensen was a casual, at most, user of the internet, and the defense has tried to prove that she was a regular user of the internet. Now, it appears that somebody was going on there and accessing sites that seem to focus on, well, they mentioned there's a lot of homosexual sites listed there, or what would appear from their names to be homosexual sites. And I'm thinking, well, what about all these penis photos from 2002? Now, who, I don't know.
And Your Honor,
these are in July. The sites are in July, so
But Mrs. Jensen didn't go from avid surfer, somebody who's going through and hitting on 100 pornographic sites a night, to somebody who was unfamiliar with the internet between July and October.
I'm not making any claims about July. I mean, there's not that, that history in July I don't think is relevant to who's using it in September, October, November, and I'm not making any arguments about July.
The state has presented evidence from which the jury could conclude that Mrs. Jensen made very little use of the internet. If the jury believes that, then the jury is going to think, well, who else in the Jensen home would have been going to sexswap.com and gay something and some of the names I don't even want to repeat, even after all the evidence has been stated in this case. From what I was looking through the names of the sites which had been visited, somebody was doing it. Now, that's where the 2002 photographs come into play. Someone who would sit at his job while he's selling stocks and be accessing sites that depict all these penises, the jury could decide, well, that makes more likely that it was Mark Jensen who was looking up these sites in 1998, which makes more relevant, that he was the one who was doing the late night internet searches for other things, which makes more likely that he is the one who planted the pictures that had kind size comparison statements in them, and so that it strikes me it does have considerable probative evidence.
How does looking at porn make it more likely that you write down that kind of statement? I fail to get that, because there's so many people using it that look at porn and don't write that statement. So I still there's a lack of similarity there. That
Well,
I don't
perhaps,
think. But on this issue, what the Internet History has, looking at those sites in July, they're not being used to confirm the identity of the user in the late fall of 1998. And I think that's more unfair prejudice.
I don't agree with you. I do think that it could be evidence from which the jury could conclude that whoever was using it in July was also the principal user in October, and that is particularly true because there has been evidence from which the jury could decide that Mrs. Jensen was an infrequent user of the computer.
And, Your Honor, I'd also point out that
The extraordinary similarity in terms of the description of these sites and the stuff that was found on the work computer. There's www.erectguys.com. That's July 10th, 1998. There's almost an entire page of that here. Then there were cctrade.com, Harry Daddy's Dad, Harry Fur. I hope, and gay internet sites, and there's truly nothing wrong with men looking up other men on the internet. I really don't have a problem with that.
I don't want to have your moral judgment. Just tell me why it has evidentiary value.
This is clearly consistent with the stuff that was on the computer, the photographs that you just looked at.
That's the thing about it. I think it's admissible.
So which is admissible now? This is all admissible. What about?
Well, as I've explained, I think that the 1998 searches are admissible to make on the issue of who was using the computer, and also on the issue of who might have been the source of exhibit number 197, and also the other pictures which are no longer available. And the 2002 materials are admissible because their existence on a computer that could not possibly have been utilized by Mrs. Jensen make it more likely that the defendant was the person who was doing the searching in July of 1998.
But now we have so many different layers, Judge. To get at, the question is, the real question is who's looking up the ethylene glycol in December?
But it all fits, the fact you're complaining that there's too much evidence. Well, we can't have too much evidence.
That is not my complaint. What we have is
too much. So many layers.
We have too many smear tactics going on.
All right, you view it one way and I view it another.
Well, but to now let in the 2002 to prove the July thing, which supposedly makes it more likely that later in the fall something is going on. It's a series of inferences without a lack. When we're using it for identity, it has to be very, very similar, and it's not. And it just is not that so similar. Does it make it more likely that he's planting those photographs? It just doesn't.
I'll say it one more time. Someone, presumably from every bit of evidence that we have, offered by either side, someone was going on and was accessing this huge number of pornographic sites, a large number of which appear to have a homosexual orientation. Now, I think the evidence also suggests that it would be either Mr. or Mrs. Jensen. The fact that similar material is found on the defendant's computer makes less likely that Mrs. Jensen was doing those searches and makes more likely that the defendant was. And the probative value outweighs the prejudicial impact. And I will grant you that there is some prejudicial impact given the nature of these pictures and other issues that it injects into the case. But, and I will give a cautionary instruction if you would like one given.
I'm open to suggestions on that because this is so prejudicial that a cautionary instruction would be great, but instruction 275 or whatever the Wisconsin jury instruction is on other acts, I think enhances the prejudice rather than minimizes it.
Well, you're not limited to 275. I will give a proper cautionary instruction if you request one.
What are all the purposes that 2002 photographs are admitted for?
If you want, Judge, I'll draft the instruction, but the reason...
You can draft one too, and then I'll choose or come up with my own.
I'll give it a go just in terms of an off the top of my head explanation of the relevance of this. This evidence is not being offered to establish that Mark Jensen is a person of strange sexual peccadillos. It's being offered merely to establish who was the more likely user of the computer during the relevant time period. It is also being introduced to establish that Mark Jensen had a unique preoccupation with penis size, and insofar as that may influence the jury's decision or the jury's conclusions as to who was the likeliest source of the photographs that were being left around the residence.
Well, I don't want to say likeliest, because it could have been anybody.
In view of the fact, in terms of the evidence, in terms of the light that it casts on the one photograph that contained the language, is his as big as mine? And then considering the subject matter that's been testified to as to these photographs, specifically, that's a significant percentage of them portrayed erect penises with women's faces in the vicinity of those erect penises. And that's what it's being offered for. And then the other part would be, in terms of the evidence pertaining to the conversation with Kelly Labonte, is being offered to establish who was the likeliest person to be using the computer on October, 23rd, 1998, when the Stiefel-Nicholas directory was accessed, the name John Jock Joseph was looked up, and then immediately after that, somebody was looking up sites about botulism and other types of poisons. That's the reason the state is offering this evidence. And I have no problem with an instruction like that. And in fact, I anticipate in my closing argument, I'll repeatedly remind the jury of that fact.
Yeah, we really don't have to worry about it because there's not a chance in the world I would accept an instruction like that. If anybody would think that's appropriate, it aggravates the prejudice tenfold. And I mean, there's absolutely no, I don't think there's any instruction in the world that's going to, I'll try to come up with one overnight because once again, I'm facing new things for which I don't think there's a quick, easy answer in terms of it, and I'll try to come up with something this evening, but I'm just not sure that there is an instruction that would work on this. We have another problem, which is, of course, they've chosen whatever they think are the photographs out of the 5,200 that are most helpful to them. I don't have all those. I didn't know that they're going to be promoting those again today, and I'm not going to. I don't think it's appropriate to allow them to select and choose that group, and I also think putting in any number of photographs to this jury is incredibly inflammatory.
Well, Your Honor,
I'm going to tell you. I don't. Well, you go ahead.
I'm going to say I'm kind of hard-pressed as to how counsel wants me to proceed in that regard, except, of course, he doesn't want me to mention it all. But the fact is, I think it's appropriate that it be mentioned. Now, here's the thing with respect to those photographs. They've already been marked as an exhibit. I had no intention of showing them to the jury. I was going to present them to Mr. Cook and ask him to describe what is contained there and to describe the manner in which these folders were organized in the file. Now, if counsel wants to go into the fact that, well, gee, there's only about 900 or 1,000 photos here, and there's another 4,500 pornographic photos in the defendant's in Mark Jensen's work computer, have at it. You know, I don't know if I were in his shoes, I'd want to go into that. But if he wants to, that's fine with me. I wasn't going to ask the witness to list the number of these photos. I was simply going to ask him to indicate that there's a large number of photos that they depict a large number of penises, that many of them are organized according to size, that they're in folders, that the folders are labeled, I think one is big, another one's bigger, another one's favorites. Are there any other folders in there?
D average, D large, D small.
D average, D large, D small. So those were the things that I was going to ask him about with respect to those photos. I wasn't going to show any of the photos to the jury, and I wasn't going to go any further than that. with respect to the work computer. Now, with respect to the home computer, I intend to go, I want him to go through the internet history, and that entire document is going to be received into evidence, and I think it should be received into evidence because it gives the jury, I think, a very clear insight as to who's looking at the computer, who's looking on the computer. Now, one of the concerns that I had originally when I saw this was, well, there's stuff on there that a heterosexual male ordinarily would not be looking at. So maybe a jury might look at that and think, well, that's probably Julie looking at that stuff. And so, again, I think that we should be permitted to refute that. And the defendant was looking at this stuff. And how do we know he was looking at this stuff? It's on his home computer. It's on his work computer 2 or 3 years later. So almost as soon as he gets that home computer, almost the first thing he starts looking at are those kinds of sites. And that's the kind of fair thing that I believe I should be able to comment on. Now, the other things, there are many other things that Mr. Cook is going to be testifying about with regard to this home computer, such as the intentional, continual deletion of the internet history as it's being accessed, which refutes the proposition that Julie Jensen was looking this stuff up as a means to frame her husband. Because if she wanted to frame her husband...
Well, we've been through that. You've explained that. All right. Did you want to say anything before I call the jury in?
Well, Judge, the court had ruled that the 2002 stuff was not admissible on other grounds. I don't know why all of a sudden it is.
Because of the 1998 material. I said earlier that he had to bring me something from 98. I expected he'd bring me a few things. He said he had 2 thumbnail pictures. Turns out he's got 149 pages of hits, not all of which are pornographic, but there's a large number.
I didn't finish my sentence, but because I'm getting at something else. Why are the names of the folders have anything to do with the 1998 stuff?
The names of the folders.
Yeah, you're just talking about
the folders, the organization. Well, again, it's this notation. His is bigger than mine, or whatever.
Is his as big as mine?
His is big as mine.
And one of the huge pieces of prejudice here is how do you defend something when the police can't keep any of the evidence, can't write a report? How do you defend against that 15 years later?
What can I tell you?
Well, that's one of the reasons we exclude things from evidence, is when it's not possible to defend and you don't have notice.
The limits on excluding evidence, which is the suppression of what the jury should know in most cases, is done only under very limited circumstances of destroyed evidence. And you know that better than I do. So I don't want to hear that. Well, you can say it, but it's not, there's absolutely no evidence of purposeful destruction in order to disadvantage the defendant.
Well, but the problem is it does disadvantage them, especially when we're talking about something where they've acknowledged they can't prove one event was done by the defendant. So I do think that really does add to the unfair prejudice here when I've got nothing to fight. It's just I mean, there's no date. It's like, I mean, it would be nice if they just said, here, we think he did this on October 10th, 1994. Well, then I can maybe find a way to fight that. How do I fight?
Look, I'm not in the camp that says because things didn't, get done exactly as they should, that I should be pulling little pieces or big pieces away so the jury can't think about them. That's a distortion of what the trial process is supposed to be all about.
Well, not only that, Judge.
No.
They have the dates. They have the dates. Julie took up a log of everything that was going on.
All right,
they have the dates.
Let's stop arguing and take some evidence. Ask the jurors to come in, please.
Take the stand.